Good evening, ladies and gentlemen, and welcome to this evening's online seminar entitled Tackling COVID-19 Through Private Law. Our speaker this evening, we're very lucky to have Dr. Soterios Loizou from King's College London. Tonight's topic, according to Dr. Loizou, the outbreak of COVID-19, the COVID-19 pandemic has exposed mankind to a global health crisis, unprecedented in scope and impact. Governments have deployed elaborate plans to alleviate the severe problems created by the reduced or complete shutdown of economic activity and the sealing of international borders. Granted, virtually no measures have been taken to restore the equilibrium in affected business relationships. The lack of rigorous regulatory intervention raises the question of whether private law can fairly address the effects of the pandemic. The answer to this question, Dr. Loizou's paper focuses on a three-dimensional review of the legal response to the problems created by this public health and economic crisis, past, present, and future. How can private law facilitate the resolution of disputes and the salvage of existing business relationships? How can private law reinstate trust in distressed markets? How can private law foresee such crises and fairly allocate the burden of coping with their impact and effects between parties? I should have added at the outset that my name is Stephen Hall. I'm just moderating here this evening at the request of Professor Witzleb, who's unfortunately had an unavoidable and unforeseen and unforeseeable timetable clash. So I'm stepping into the breach for him this evening. Now, we're very lucky this evening to have Dr. Soterios Loizou, who is a senior lecturer, or if you prefer, associate professor in commercial law at King's College London, where he teaches and conducts research in the areas of commercial law, conflict of laws, and international arbitration. He has also served as the TTLF Fellow at Stanford Law School, Hauser Global Fellow at New York University School of Law, and has held visiting faculty positions with Peking University School of Transnational Law, the University of Ferrara, and the University of Nicosia. For his research, Soterios has been awarded numerous awards and prizes, including the prestigious Colin B. Picker Prize at the American Society of Comparative Law and the Smith-Lowenfeld Prize by the International Arbitration Club of New York. Now, the order of proceedings from this point forwards is that Dr. Loizou will have 45 to 50 minutes within which to present his ideas to us. During that time, if you are so inclined, you can pose questions through the chat function. And then at the end of Dr. Loizou's presentation, we'll have 5 to 10 minutes budgeted for answers, for me putting those questions to Dr. Loizou and for his answers. So without any further ado, and with much personal anticipation, I now hand the electronic floor over to Dr. Loizou. Thank you so much.
Thank you. Thank you very much, Professor Hall. Thank you very much for this very kind introduction. I understand I shall share my screen right now. I shall share my PowerPoint. I understand. Yes, can you see the PowerPoint? Is it visible on your screens? Yes, that is wonderful. So good morning, good afternoon, good evening to all, depending on your location. I am Soterios Loizou. The title of my presentation today is Tackling COVID-19 Through Private Law. Before delving into the role of private law in alleviating the difficulties created by COVID-19, I would like to thank Dean Wolf and Professor Witzleb, of course, for the very kind invitation to present my research at the CCTL Obligations Lab Asia at the Chinese University of Hong Kong. As already suggested, over the next 45 to 50 minutes, hopefully I will be within this time frame, I will try to explore whether private law has the necessary tools and can fairly address the effects of the COVID-19 pandemic effectively. So by now, it is tried that the outbreak of the COVID-19 pandemic has exposed mankind to a global health crisis that is unprecedented in scope and impact. Millions of people have been infected, millions of people unfortunately have passed away, and almost the entire species has been affected by the pandemic. Indeed, the pandemic has reached almost all of us, considering that it has become more global compared to the disastrous World War I and World War II. As one would expect, at the forefront of the race to tackle this crisis, one found and still actually finds doctors, nursing staff, medical research teams, institutions, and pharmaceutical companies trying to develop effective protocols, vaccines, medications to cure the virus, or at least limit the effects of this virus. The pandemic struggle, however, is not limited to our biological survival as a species. On the contrary, it extends to preserving our cultural and growth achievements by avoiding an economic catastrophe on both global and regional levels. To that purpose, governments and intergovernmental organizations such as the European Union have attempted to intervene to alleviate the severe problems created by the reduced or complete shutdown of economic activity and the sealing of borders. And they acted through legislative packages to save the lives of their citizens through the establishment of a safety net for the economy, for employees, for enterprises. Health was put first, money was put second. Society was put first, economy took the backseat as it was expected. Nevertheless, as will be explored later in this presentation, these initiatives and public measures took place after the COVID-19 outbreak, and of course were distinguished by their reactive nature. Hence, in juxtaposition with medical professionals who were placed at the forefront of this battle, laws, lawyers, and law producers have been perceived as doing too little, too late. I will respectfully try to challenge this perception and illustrate the role of private law and the legal tools available in classic private law to tackle the effects of the COVID-19 pandemic. To this end, my presentation focuses on a three-dimensional review of the legal response to the problems created by this public health and economic crisis. Past, present, future. These are the three dimensions. How can private law facilitate the resolution of disputes and the salvage of existing business relationships? How can private law reinstate trust in distressed markets? This is the present. And how can private law foresee such crises and fairly allocate the burden of coping with their impact and effects between parties in the future? The emphasis will be placed on contracts and more specifically international business transactions. The emphasis will be on contract law, contractual obligations. Besides, it is Obligations Lab Asia, and especially obligations assumed under contracts that are distinguished by elements of internationality, such as the archetype, international business transaction, the international commercial agreement par excellence, and I'm referring, of course, to the international sale of goods contract. Hence, matters pertaining to the dissemination or processing of personal data, such as the vaccination status of a person or whether a person has been infected or not, the impact of regulations on employment relationships and layoffs, the role of national regimes and international conventions protecting intellectual property rights and providing incentives for the development of vaccines and medical protocols to cure the virus, or even compensation schemes for adverse effects of these protocols and vaccines, just to name a few matters, fall outside the scope of this paper. We will be focusing exclusively on contracts and especially international commercial contracts. Let's begin with the past. Let's begin with resolving disputes and salvaging business relationship. And perhaps that is disproportionately heavier in my presentation compared to the other two dimensions, clearly because it is the most important from a business law perspective, from the legal practitioner's perspective. The quick contagion rate of COVID-19, the first, the second, the third, let's hope that we will not have more waves of virus outbreaks, mandate extreme measures to gain valuable time so that the line of infections and casualties is straightened, so that it does not overwhelm the national medical care systems, thus leaving patients without treatment, thus leaving patients without hope. And that is something that we do not want. And this has taken the form of travel bans and restrictions, gathering restrictions, suspension of all non-essential trade, anything but food, medicine, banking, financial, and insurance activities, and seemingly never-ending lockdowns, which have been quite painful, I have to say, to all of us. You can still see the PowerPoint, right? Yes, it's not frozen. Just a thumbs up would be great. Okay, so as a result of these measures, international trade has suffered from a sudden scarcity of resources, which crippled trade routes and greatly tilted supply and demand, thus upsetting individual transactions, which were now facing imminent default by contracting parties. It was not the virus itself that was actually creating these problems. It was not the virus itself that interfered with international commerce, but rather the public response to the virus, which raised obstacles in the performance of already assumed contractual obligations and increased uncertainty for the conclusion of new business deals. Indeed, over the past 2 years, merchants have experienced a series of contractual breaches, which can be attributed to 3 broad categories of legal issues. Firstly, belated performance under the contract. Secondly, complete or temporary impossibility to perform under the contract. And thirdly, lack of readily available raw materials, which at a second stage led to increased prices for goods and services. And this last legal issue of increased prices has further been exacerbated by quantitative easing, the rise of inflation, and of course, the conflict in Ukraine and the sanctions that followed. Granted, as great as the difficulties caused by COVID-19 might seem, they do not constitute novel problems in private law theory and practice. On the contrary, supervening circumstances have already been regulated since the Code of Hammurabi, where provisions was made to adapt to storm god who unexpectedly inundated fields and ruined the produce. Indeed, almost 4 millennia ago, 4,000 years ago, this famous compilation of rules enshrined provisions on exactly these points. And firstly, Section 45, and I hope that you can see that on the slide, and it's not, the letters are not too small. Section 45 stipulates that if a man rent his field to a tenant for crop rent and receive the crop rent of his field and later Adad, the storm god, inundate the field and carry away the produce, the loss falls on the tenant. And secondly, Section 48 stipulated that if a man owe a debt and Adad, again, the storm god, inundate his field and carry away the produce, or through lack of water, grain have not grown in the field, in that year, he shall not make any return of grain to the creditor, he shall alter his contract tablet, of course they were using contract tablets back then, and he shall not pay the interest for that year. What do we see? In a nutshell, we see that sections 45 and 48 allocate the risk of accidental loss of or destruction of the goods between the parties as a result of unforeseen or supervening circumstances. Pursuant to Section 45, if a farmer rents a piece of land, agrees to pay and actually pays rent, and subsequently the produce is destroyed, she cannot go back to her counter-contracting party to claim reimbursement of the money paid. It doesn't make sense. Conversely, under Section 48, if the farmer had debt that he could not repay because his produce was destroyed due to inclement weather, the farmer was absolved from liability to pay capital and interest that year. So we see that it is shared between the two parties. And this example illustrates that in casu, in the case at hand, it might be nonsensical or even unfair to insist on performance under the contract, thus highlighting the role of private law in alleviating the difficulties caused from such supervening events. Fast forward to contemporary legal regimes, rules of this kind covering unforeseen and supervening circumstances can be found in various modern national and international instruments, albeit they follow different theories and adopt different approaches to these problems. Classic examples are the concepts of force majeure, of course, hardship, frustration of contract, frustration of the common purpose, if we would like to go with that, act of God, change of circumstances, imprevisión, imposibilité, excessiva onerosità, clausula rebus sic stantibus, and so on and so forth. Way too many to delineate right now. Just very briefly, without delving in too much detail, in English common law, and to the extent that this still applies in Singapore and of course in the special administrative region of Hong Kong, the sanctity of contract is triumphant, with force majeure manifesting only as a contractual arrangement between the parties. Frustration of contract is the only way to disentangle from a transaction when the circumstances have become in a fundamental respect different from those which were envisaged. In like manner, frustration of the common purpose between the parties can also release the two contracting parties from their contractual shackles. And I'm using the term shackles because if the common purpose of the contract is no longer there, the contract ceases to be a means to affluence, but transforms into a burden on the parties. If we move to continental Europe and in civil law jurisdictions, in French and Dutch law, for example, special rules provide for the exemption from liability, while other special rules put remedies of contract adaptation and contract termination on par. A similar approach has also been enshrined to the extent that I understand in the civil code in mainland China. Other legal orders, such as Austria and Greece, allow courts to either terminate or adapt the contract, albeit preference should be given to the preservation of the contractual arrangement, termination being an ultima ratio, as we say in Latin. Well, in a purely domestic environment where all subjective and objective elements of the deal are linked to a single jurisdiction, the relevant rules on supervening circumstances will kick in to allocate the burden between the parties. In international contracts, however, where the contract and the ensuing disputes are linked to more than one jurisdictions, it becomes apparent that the application of a different law could lead to different positions of the parties and different options and remedies available to the parties. And the risk associated with these legal differences is greatly, of course, is greatly limited through choice of law agreements and the almost universal acceptance of party autonomy. Choice of law agreements can crystallize the legal framework of an international business transaction, thus allowing the parties to structure their deal in the shadow of the selected applicable law. Although accurate numbers cannot be offered, empirical research in the published statistics of the ICC International Chamber of Commerce arbitrations over the past 15 years indicate that approximately 84% of contracts underlying disputes submitted with the ICC contain a choice of state law for the regulation of the agreement. So the parties can select the law and avoid the applicable law, the law governing their contract, and avoid any intricate, complex conflict of laws exercises, which could lead to different laws, which they had not foreseen at the time of the conclusion of the contract. And regarding the legal system selected, the picture remains opaque, albeit clear enough to note that English, Swiss, French, German, New York state, and California state laws dominate international business transactions. Soft law instruments, to the extent that they do not form part of these laws, they are just selected as self-standing instruments in arbitration in a very limited number. Actually, over the past 15 years, I have seen less, I have counted fewer than 200 to 250 cases where soft law was selected directly by the parties. Hence, when the parties select the applicable law, when the parties select the lex contractus, the law governing their contract, they also select the relevant rules on supervening circumstances. And that, and through this mechanism, we avoid difficult aspects of conflict of laws exercises. Speaking of choice of law agreements, it has been argued in legal theory that problems might arise when national laws with different legal positions simultaneously govern the same contract. That would be the case of the passage. Although intellectually stimulating, having one part of the contract governed by English law and another part governed by, say, French law, although this is intellectually stimulating, this seems to be more of a problem residing in academic imagination rather than real-life practice. Besides, as noted in the comments of Section 168 in Restatement 2nd of Conflict of Laws in the United States, contracting parties hardly indulge into legal experimentation. Their choice will more often than not be supported by a business rationale. If they were savvy enough to subject different parts of their contract to different legal regimes, one would expect that they would also have included force majeure and hardship clauses in their transaction, thus derogating from the default, the dispositive rules of the applicable laws. This scenario is different, however, from that where we have the courts in country A or the courts in jurisdiction A called to apply the force majeure or hardship rules of country or jurisdiction B. Although such scenarios do not raise intricate theoretical inquiries, difficulties might arise in the ascertainment of the content and the actual interpretation application of the foreign rule by the court. Indeed, one cannot exclude the possibility of a somewhat adapted application of the foreign rule, which would bring it closer to the corresponding provision in the lex fori, meaning that if the lex fori allows for negotiation and adaptation of the contract by the adjudicatory authority, one should expect that the courts of the forum, that the adjudicatory authority at the forum will interpret and apply the foreign law in a somewhat similar way that this particular issue is regulated by the law, by the substantive law of the forum. From this relatively a broad overview and analysis so far, one cannot but appreciate that notwithstanding the availability of provisions regulating supervening circumstances, this lack of consistency and coordination of national laws might hamper economic recovery in the aftermath of the pandemic crisis, particularly in relation to chain transactions. Chain transactions where we have multiple, say, sale of goods contracts, a chain of sale of goods contracts where we have multiple sales agreements, which are governed by different laws, thus triggering the application of different legal standards down the chain. And this amplifies the importance of global legal unification in relation to international commercial transactions. And indeed, provisions on supervening circumstances can also be found in international uniform law instruments too, both hard and soft law instruments, such as the UNIDROIT principles of international commercial contracts, the 1970 Convention on Travel Contracts, and the 1956 Convention on the Contract for the International Carriage of Goods by Road, CMR. Now, these international uniform law instruments can apply directly when they have been integrated in national law. They have formed integral part of national law by accession, ratification, or approval by the legislative body of the particular jurisdiction. They can largely be selected as governing regimes for international business transactions, especially in the context of arbitration. They might inform the interpretation and application of other international uniform law instruments, and even be triggered when the ascertainment of the applicable law would take too long or be very expensive in legal proceedings at hand, thus applying an international uniform law instrument which has been crafted especially for cross-border situations when we cannot easily or when the parties do not want to ascertain the content of the applicable foreign law. Speaking of international uniform law, let us focus on the archetype international business transaction, the international sale of goods contract. And when discussing about international sale of goods contracts, one cannot but look at the UN Convention on Contracts for the International Sale of Goods, the renowned CISG. The CSG entered into force in 1988 with the simultaneous ratifications by the United States and China, and to this day counts almost 100 ratifications, including all major trade nations other than the UK and India. And of course, UK, I do not anticipate that will accede to the CSG, considering that the UK treats UK law and the UK Sale of Goods Act as a commodity, and English law by extension, okay? Now, interesting enough, Chinese University of Hong Kong, 20 days ago, a declaration of extension of the territorial application of the CSG to Hong Kong was deposited. So by approximately at the end of the year, we will have the application of the CSG, or the extension of the application of the CSG to Hong Kong as well. And that is of particular importance, especially with regard to contracts, not only that are linked to Hong Kong, but when we have the selection of Hong Kong law as the lex contractus. Now, this wide accession of to the CISG renders the convention one of the most successful, at least in terms of number of ratifications, private law instruments in the world. And because of this wide accession to the CISG has inspired its characterization as a high expression of a modern law of the merchants, of a modern lex mercatoria, as we say. Setting aside the controversial topic of whether a modern lex mercatoria exists as opposed to a medieval lex mercatoria that actually existed, it has been estimated that the convention governs approximately 80% of all international sales transactions, setting aside opt-outs on the basis of Article 6 of the CISG. As indicated in its name, the ambit of the CISG encompasses international sale of goods contracts, although many commentators argue for the interpretative expansion of its scope to similar transactions such as barter contracts, preliminary agreements, distribution agreements, framework agreements, and so on and so forth. So the CISG is of particular importance. CISG, does it encompass, does it enshrine rules on force majeure and hardship? Well, our port of call is Article 79 of the CSG that you can see on the slide. The CSG enshrines rule on force majeure in Article 79, a hotly debated article during the diplomatic negotiations, and of course, tons of ink have been used to explore the ramifications of Article 79 over the years. Inspired by the exemption rule that we find in Article 74 of the previous convention, the predecessor of the CSG, the UNIDROIT Convention related to uniform law on the international sale of goods, which was quite successful in Europe, but unsuccessful in the rest of the world. Article 79, paragraph 1 stipulates that a party is not liable for a failure to perform any of his obligations if he proves that the failure was due to an impediment beyond his control and that he could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract, or to have avoided or overcome it or its consequences. Succinctly, pursuant to Article 79, in the event of breach of contract due to an impediment beyond the party's control, of course, the breaching party can exempt herself from liability for damages. The exemption granted under the CSG merely freezes this remedy of damages, including liquidated damages and other contractually agreed penalties if these liquidated damages and penalty clauses were to be considered as valid by the applicable law. All other remedies, however, such as reduction of the price, avoidance of the contract, interest for sums in arrears, they remain available for the aggrieved party. All that Article 79 does is to exempt the breaching party from liability that is triggered as a result of the breach of contract because of the supervening circumstances. And the exemption is affecting only for the period during which the impediment exists. And should the impediment be lifted and non-performance persist, damages will be available, of course, for the breach committed by that particular breaching party. That is very important regarding international sale of goods contracts caught up by national legislative packages tackling COVID-19, which rendered performance temporarily impossible. For example, we had a trade ban, we had restriction of exporting certain kind of goods, for example, face coverings, masks, vaccines, pills, whatever that might be. So if we have a temporary impediment, then the supervening circumstances and the exemption of from liability will be temporary as well. As lockdowns, however, are imposed and lifted, the effects of Article 79 of the CSG will vary accordingly. Briefly, for Article 79 to apply, there must be an exogenous impediment which resulted in the breach of contract by the breaching party. We need an impediment that fell outside the breaching party's sphere of control, an impediment that was not foreseen and could not have been foreseen at the time of the conclusion of the contract, and an impediment that could not be avoided or its consequences could not be avoided by the breaching party. Hence, pivotal role plays here the characterization of a certain event as a such as the COVID-19 pandemic, as an impediment that would fall under Article 79. Of course, you know very well that with the exception, say, of what is a place of business, that we find some elements in Article 10 of the CSG, and what is a fundamental breach of contract that we find in Article 25, and perhaps what is the damages that we find in Article 74, but that is an extrapolation. We do not have definitions enshrined, delineated in the CSG, and the same applies with the concept of impediment. As a result, we need to come up with an autonomous definition of what is an impediment on the basis of Article 7, paragraph 1 of the CSG. Hence, if an autonomous definition were to be coined, an impediment would encompass any event which firstly renders performance impossible or nearly impossible, at least for a limited period of time, and secondly, falls outside the sphere of control of the non-performing party. Whether a particular event falls within or outside the non-performing party sphere of control shall be determined, of course, on a case-by-case basis. The existence of the impediment shall be determined objectively, independently of the fault or negligence of the breaching party. And legal theory and jurisprudence have actually set forth quite a few instances which could arise as impediments. For example, natural disasters, inclement weather conditions, earthquakes, war or warlike operations, terrorist or piracy attacks, epidemics, which is a scale below the pandemic, blockade of transport routes, of course, and availability of loading and unloading facilities at the port of destination or port of loading, labor strikes outside the sphere of control of the particular enterprise, and so on and so forth. The question that naturally arises at this point is whether the pandemic itself or trade restrictions as a result of the pandemic constitute an impediment that falls under Article 79 of the CSG, and whether actually this pandemic, COVID-19, as we stand right now, or as we experienced it 2 years ago or a year ago, shall be determined, as always, on a case-by-case basis. The time when the impediment occurred is completely irrelevant because the CSG does not distinguish between existing or subsequent impediments. However, the existence of this impediment at the time of the conclusion of the sale of goods contract could bear on the foreseeability and, of course, the unavoidability of the impediment. The other requirements that we need for the application of Article 79. For the sake of completeness, and I do not want to, again, to delve into too much detail, and perhaps we have delved into too much detail with regard to Article 79, but it is key with regard to international business transactions. Another requirement, although it is not clearly a requirement for the application of Article 79, is that we need a notice to the counter-contracting party advising of the impediment, including the permanent or temporary nature or and the effects, of course, of the impediment on the ability of the breaching party to perform her contractual obligations. This notice must be effected within a reasonable time. It doesn't have to be effected in writing. It doesn't have to be reduced in writing. It can be made orally, but of course we would need some kind of evidence there. And if we do not effect this notice of supervening circumstances, that we have an impediment that precludes us from performing under the international sale of goods contract that is governed by the CISG, if we fail to provide this notice, then we would be exposed to liability for failure to provide this notice and for the loss sustained because of the omission with regard to this notice. This is the regulatory framework pertaining to force majeure under the CSG. It is not that different from national regulations, and it makes sense because an international uniform law instrument that has taken the form of an international convention, it has been rigorously negotiated in a diplomatic conference, and of course, representatives from various legal traditions have come together and tried to find the common denominator that would be enshrined in a particular rule. So Article 79 is not something unique. It is something that we also find in national laws, and it's not something surprising. And that also is reflected in soft law instruments as well. If we turn to soft law instruments and we have a look, for example, at Article 717 of the UNIDROIT principles of international commercial contracts, or even the principles of European contract law, or the draft common frame of reference, a very ambitious academic project that was seen by some, it was viewed by some as a precursor to a European civil code, a European Union civil code. They follow exactly the same positions. We have an exemption from liability for damages, and all other remedies are preserved. With regard to specific performance, of course, we have the classic position impossibilium nulla est obligatio. If we cannot, if something is impossible, we cannot impose this burden on the party to perform something that is impossible, of course. The question now that naturally arises, if force majeure is regulated in roughly the same way as in other, as in most jurisdictions, and it is something predictable and not surprising, what about hardship? Hardship is of particular importance, especially not only with regard to COVID-19, but especially today with these price hikes that we have been experiencing and witnessing in raw materials. The CSG does not contain special rules on hardship. So we see that if the CSG covers 80% of international sale of goods contracts, and international sale of goods contract is the most important international commercial agreement, we do not have a clear rule on hardship in the instrument that is supposed to govern most of international business transactions worldwide. And this shortcoming has ignited academic discussion, with legal theory and jurisprudence remaining split on whether hardship is governed by the convention, or in the alternative, whether courts and arbitral tribunals must resort to the otherwise applicable law to fill the gaps of this international uniform law instrument. This academic debate has been eloquently set forth in the CSG Advisory Council Opinion number 7 on the exemption of liability for damages under Article 79 of the CSG. And ironically, this particular opinion number 7 on exemption of liability for damages because of supervening circumstances was adopted by the Advisory Council in Wuhan, China, in October 2007. What a coincidence. It is the irony of real life exceeds the imagination of lawyers, and hopefully, and I'm very thankful for that, that reality exceeds the imagination of lawyers. But anyway, interestingly, going back to the CSG and legislative drafting, interestingly, the legislative history of the convention does not offer any meaningful aid in clarifying this matter. And we refer to the legislative history because we are dealing with an international convention. And if we refer to the 1969 Vienna Convention on Law of Treaties, we have this option on the basis of Articles 31 through 33. Now, as a matter of fact, the preparatory works of the CSG and what happened during the diplomatic conference have been used by scholars to reach diametrically opposing conclusions. So we have many positions. It is not clear which position applies under the CSG. The CSG is the most important international uniform law instrument to date. It forms integral part of the laws of the most important trade nations other than the UK and India, and we do not have a clear position on change of circumstances. Indeed, as you can see on the slide, I have grouped four main positions. The various theories, I have grouped them in four main takes, four main prongs. Firstly, hardship and change of circumstances which do not lead to complete or temporary impossibility to perform falls completely outside the scope of the CSG because it falls under the concept of validity, which is excluded from the scope of the convention by virtue of Article 4. Hence, the otherwise applicable law will have to apply. The non-uniform state law that applies to the case at hand will have to be triggered, and the relevant rules on hardship should apply to the case at hand. Secondly, it has been argued that hardship, because it pertains to the rights and obligations of the parties, issues that fall clearly within the scope of the CSG by virtue of Article 4, it falls within the regulatory scope of the convention, but absent any clear special rules or general principles of the convention, we cannot find a regulation, we cannot craft any rule by analogy. So again, we go to the otherwise applicable law by virtue of a conflict of laws exercise. And then we have situations 3 and 4, where again, it is found that hardship pertains to the rights and obligations of the parties. One finds that actually it is governed by Article 79, and then we have a question whether we need to limit the remedies available to the parties only to the exemption of damages, as Article 79 says, or take it a step further with renegotiation, adaptation, and termination by the adjudicatory authority, or we proceed with an internal gap, and then we trigger general principles of the CSG if there are any general principles of the CSG to fill this particular internal gap of the instrument. Now, having briefly noted the difficulties that one might encounter in interpreting and applying the CSG in hardship situations, let us explore what happens in soft law instruments. And you will appreciate in a second why it is important to have a look at soft law instruments. And it's very important, just a spoiler here, because in some courts, especially Supreme Courts in France and Belgium, these soft law instruments have been used to fill the gap of this international uniform law convention. With regard to soft law instruments, of course, our first port of call, and I believe that this should be the only one because the rest of the soft law instruments, they have copied or they have been inspired by the unit law principles. If we go to Articles 621 through 623 of the unit law principles, we can find a three-tier regime of how to tackle hardship situations. First things first, the unit draw principles, which is again a soft law instrument that has influenced the practice of international business transactions and contract law on a global level, and especially Chinese contract law. We find in 621 the pacta sunt servanda principle. The parties are bound by the contract, even if their respective performance has exposed become more onerous. You have agreed to perform under the contract, you must perform under the contract. Secondly, we find in 622 a general rule that contractual obligations must be fulfilled, but exceptionally can be derogated from only in the event of hardship. And then we go to 623, where we have a delineation of the remedies available in the event of hardship. And we find there the possibility, actually the requirement for renegotiation between the parties. And if this fails, then the adjudicatory authority can either terminate or adapt the contract on its own as it deems appropriate. And exactly similar rules, not exactly the same, but similar rules. At least in their essence, we find the principles of European contract law and the draft common frame of reference. I wish I had access to the principles of Asian contract law. Unfortunately, I do not, so as to pair the discussion with the principles of Asian contract law as well. But I anticipate that we would have very similar positions there, considering the practical harmonization of law and the practice of contracts for thousands of years now, especially sale of goods contracts that we have been using as a species for thousands of years now. Now, at this point, one can appreciate the different positions that we find under a hard law instrument, the CISG, where typically we will have exemption from liability and exemption from the obligation, from the remedy, essentially of paying damages, and with a question mark of whether we can have other remedies. And we have the UPICC, which mandate renegotiation between the parties and termination or adaptation of the contract by the adjudicatory authority only if these renegotiations fail. In essence, the unit law principles favor the preservation of the contract. Renegotiation or adaptation, however, do not seem to be available under the CSG, at least in the first place. At least prima facie, we do not have adaptation or renegotiation. Now, this has led to significant problems that plague theory and practice of international sales law. That is a very important aspect, and I will share also two examples very shortly with you. Now, what is the difficult theoretical and practical problem that we find in international sales law with regard to the interplay between the CISG and these soft law instruments? Well, considering that the CISG does not enshrine a hardship rule, or even if we consider that the hardship falls under Article 79, but Article 79 says only damages out of the window, all other remedies available, specific performance, of course, so. It has been argued that on the basis of the general principles of pacta sunt servanda, cooperation in the performance of the contract and good faith that we find in Articles 71, 72, and 60A of the CSG, the contracting parties are required to renegotiate their agreement. And should such negotiations fail, inspiration could be drawn from the unit draw principles to proceed with either adaptation or termination of the particular contract at hand. Any argument of using the UPICC and proceeding with a creative gap filling of the CSG by using the unit draw principles just like that seems, however, to disregard the very structure, the rules, and the principles of the conventions. Other than the remedy of price reduction, which of course, it is very similar to contract adaptation in that we adapt a price term, there are no special rules offering support for or other general principles that would mandate the renegotiation or adaptation of the sale of goods contract by the adjudicatory authority. Furthermore, the various general principles arising from the CSG may lead to incongruent results regarding hardship matters. We have pacta sunt servanda, which is a very important principle under the CSG. At the same time, we have good faith principle with a question mark because it is not clear and it is hotly disputed whether good faith constitutes a general principle under the convention or it is just a principle for the interpretation of the convention's rules. But in any case, what we do or what courts do by using automatically, directly, the unilateral principles to interpret and fill the gaps of the CSG seems like putting the cart before the horse. It is exactly this problem that has led to severe criticism of various French and Belgian court decisions on exactly this matter. And actually, the French Supreme Court, the Cour de Cassation, and the Belgian Supreme Court, again, the Belgian Cour de Cassation, they have rendered judgments where they almost automatically, when they apply Article 79, instead of exploring Article 79 of the CSG, exploring whether actually hardship falls under Article 79 and what are the remedies available under Article 79, the judges went directly to apply the unilateral principles. And they have allowed for they have requested the renegotiation of the contract between the parties or proceeded with adaptation or termination of the contract. And that has been done by French and Belgian courts repeatedly, and especially with regard to a judgment from the Belgian Cour de Cassation, the so-called Scaffold case. There were many papers, one of which by a leading scholar in the CSG, characterizing this particular case as the worst case that has ever been there, because it completely destroys the structure of the CSG and disregards the way of filling the gaps of the CSG under Article 7, paragraph 2. Theoretical as this review might seem, two examples may illustrate the practical pertinence of this previously delineated line of argumentation. Let me give you one from Europe and one from Asia using Hong Kong law, and perhaps you can transpose this with regard to litigation in mainland China as well. Now, let's imagine a dispute between the European Commission and the big pharmaceutical company. The two parties, the EU Commission and the big pharma, have concluded a contract under which the big pharma promised to manufacture and deliver several millions of vaccines. Due to supervening circumstances, the big pharmaceutical company's production line suffered delays, which precluded the pharmaceutical company from delivering the vaccines in a timely manner. Of course, we understand that the European Commission was not very happy because European citizens were passing away, were hospitalized with significant effects of COVID-19, and the dispute arose. The parties, their lawyers, and the public started scrutinizing the agreement because that is the only point where we're called in. That is the only point where we look at the terms of the contract when a dispute arises, and they find two very pertinent terms. One, a choice of law agreement identifying Belgian law, the laws of Belgium, as the applicable law, and secondly, a choice of court agreement conferring jurisdiction to Belgian courts. Now, that is very, very, very interesting for the following reason. If the European Commission wants to avoid the contract, to walk away from the contract, it doesn't want to be bound to renegotiate the contract or to provide the court with the power to adapt the contract and keep it alive. So the question that naturally arises is, if we have a contract where we have the sale of vaccines, movable, tangible objects, hence we have a sale of goods contract, and if this pharmaceutical company is outside Belgium, because in Brussels is where the EU Commission is headquartered, say that it is in the UK, in Cambridge perhaps UK, hint hint, wink wink, AstraZeneca, the CSG applies. And if the CSG applies and we proceed with an interpretation of Article 79 in light of the UNIDROIT principles, as it is happening in Belgium by Belgian courts when they apply the CSG, it means that the EU Commission would be bound by a contract from which it would like to be freed. So you see that it is very important to select the forum of the dispute. It is very important to select the forum of the dispute before of the legal differences in the interpretation application of Article 79 and the various approaches that have been adopted by the various state courts and other tribunals all over the world as a result of the virtual lack of a supranational adjudicatory authority interpreting the CSG. And this example that I have just given you, it is devilishly similar to the dispute between the European Commission and indeed AstraZeneca and where it was going. And it struck me that the lawyers of the European Commission did not even scrutinize the articles of the CSG and how the CSG is applied in Belgium by Belgian courts with regard to this particular topic. So you see that forum shopping is very, very, very important. Yes, it is a concept that has been criticized and has been ridiculed by many, but I am a proponent of forum shopping, at least with regard to a private legal practice. Let's take exactly the same dispute, exactly a very similar dispute between two parties that have selected Hong Kong law and courts in Hong Kong to resolve the dispute. Let's assume that the CSG has entered into force and it forms integral part of Hong Kong law, and the Hong Kong courts will have to apply it in the first place, primo loco, as we say, because it is more special and it is more efficient compared to the conflict of laws exercises, the conflict of laws regimes, as we have seen in international uniform law theory. Now, the question is, if the Hong Kong court will consider that actually Article 79 does not cover hardship, where should it go? It should go to the frustration doctrine. Can we have renegotiation or adaptation of the contract under Hong Kong law and the frustration doctrine? Unlikely. If the court, however, were to apply the UNIDROIT principles to fill the gap of the CSG, we would have exactly that situation. So you see again that although we have a single instrument, we have an international uniform law instrument that is supposed to unify the law, we could have a completely different outcome depending on the stance adopted by the adjudicatory authority and, of course, the court or the arbiter tribunal where we would be presenting the dispute. Essentially, forum shopping triumphant. The perks of a widely ratified international convention without a supranational adjudicatory authority deciding in an authoritative manner how the CSG, how the instrument should be interpreted and applied on a global level. Now, the difficulties arising from the diverging national laws and the lack of supranational authority that would authoritatively interpret the CSG amplify the importance of contractually allocating the risk between the parties by virtue of a force majeure, a materials adverse change, or a MAC, or a hardship clause. Such an agreement between the parties would amount to a derogation from the default, the dispositive rules of the applicable regime, be it state law, international uniform law, or a self-standing soft law instrument that has been selected by the parties, presumably in the context of international arbitration. The validity of such clauses shall be determined by the corresponding validity rules of those regimes. And interesting enough, when it comes to the CSG, validity issues fall outside the scope of the CSG, so we need to go to the otherwise applicable law that governs all other matters and fills the gaps. If we go to other instruments, such as the UNIDROIT principles, the principles of European contract law, and the DCFR, we see that the validity of this particular force majeure or hardship clauses will have to be scrutinized so that it is not grossly unfair, so that it is not going against good faith, or it is not contrary to fair dealing. Again, very interesting points pertaining to the validity of these force majeure and hardship clauses. So we're not protected even when we have a contractual arrangement between the parties. We need to be very careful. Whether a particular, and that is, and here we come to a very important aspect here, whether a particular clause covers COVID-19 as within its scope, whether it brings COVID-19 and the effects of COVID-19 within its scope is a matter of construction. It is a matter of contractual interpretation under the respective lex contractus, under the respective governing law. As an exception to the pacta sunt servanda principle that the contracts, that the agreements must be honored, such clauses are typically interpreted in a narrow sense. Empirically, regarding contracts concluded before the outburst of the coronavirus in late 2019, early 2020, nobody knows exactly when, references to a pandemic were virtually non-existent. Yes, there were some references to epidemics, which is a scale below the pandemic, but it was questionable whether the impossibility was due to the virus itself, or whether actually the difficulties arising from the national legislative measures were actually due to the hardship that was created. That said, be that as it may, in these force majeure and hardship clauses, typically we will come across fait de prince or action by government or catch-all provisions, which would bring all these national legislative packages that introduce restrictions under the coverage of the force majeure and hardship clauses. Even if COVID-19 per se, even if the virus per se was not impacting on the contractual arrangement between the parties. One might, however, wonder whether the unforeseeability and unavoidability elements frequently set forth in force majeure and hardship clauses would be met any longer regarding future shutdowns of economic activity or future restrictions in trade. Say that we have the first wave, everything closed. What about the second wave? Was that an unavoidable or an unforeseeable element? Yes, I will speed up. Thanks a lot. Thanks a lot. That is something. Yeah, apologies for running late. So was it unforeseeable or unavoidable? Well, to answer this query, of course, we need to have a look at the content of the agreement and the facts of the case at hand. Now, we have seen national law, international uniform law, the exercise of freedom of contract and party autonomy, not only in selecting choice of law, but also crafting force majeure and hardship clauses. But is that clear where we're standing? The answer is not. Actually, we're not clear. On top of that, we have overriding mandatory rules that upset the entire structure of conflict of laws exercises, that upset the choice of law agreements to the extent that we have incongruent rules there. And actually, various countries, including China, Italy, and Germany, they have promulgated such overriding mandatory rules which prevail over the choice of law agreements between the parties and prevail over the substantive rules of the applicable law. From this succinct analysis of the regulatory framework of distressed contracts and business deals, one can safely assert that private law has tools, has sufficient tools to tackle the adverse effects of COVID-19 and its impact on existing business relationships. It is just that the shortcomings of the law do not allow for them to be in full effect. If I may have one more minute to cover the present and future, that would be great, or even half a minute.
Well, let's hear. It's very interesting so far. Let's see what the present and the future say in as short a time as we can manage.
Yes, absolutely, absolutely.
Thank you.
Just a minute. Thanks a lot, Professor Hall. Thanks a lot. Thanks a lot. And thanks a lot to everybody for the understanding. I'm sorry I got carried away by the analysis. Turning to, so when it comes to existing disputes, yes, we have tools but because of the shortcomings of the law, we might not see the full force of the law applying and actually catering to the needs of contemporary trade. When it comes to present and rebuilding trust and creating opportunities, we will see that because of these effects of the COVID-19 and the shutdowns and the price hikes of raw materials and the inflation that was caused because of the stimulus and the difficulties that we have encountered with regard to the supply chains, we will be experiencing insolvencies of various corporations, insolvencies of various enterprises. And what happens next? What happens next is economic recession. So what enterprises will be focusing on will be securing liquidity, securing cash flow. And how this happens if we have an increase in interest rates, when we have hikes in the interest rates by banks, well, that does not mean that we will not have capital available. It means that we will need collateral. We will need to use classic concepts in private law, such as property rights, mortgages, intellectual property rights, orthodox guarantees to secure these loans. And no merchants will alienate their assets without ensuring that they will get an asset back. And this is assisted, this is facilitated by the use of soft law instruments as well, such as the UCP 600 for documentary letters of credit or the URTG 758 for demand guarantees. And if we take it to an international level, we could also see the 2001 Cape Town Convention and the accompanying protocols, the amending protocols of the Cape Town Convention, allowing for secured financing with regard to mobile equipment of particular importance for farming, for the farming industry, and of course, other leading industries in the world. And coming to the future, any future perspectives? Well, what we have seen so far is that private law, to some extent, it can take us, but we're not very sure whether it can help us with the unprecedented amount of litigation that is coming our way and the difficulties that we have been experiencing with regard to contracts. That means that lawyers and parties need to educate themselves with regard to the regulatory frameworks. They need to carefully craft detailed force majeure and hardship clauses and take into account the possibility of new lockdowns and new difficulties on the horizon. And that applies also to legislators. And I will close with that. And thanks a lot, Professor Hall, and everybody for your patience here and for allowing me to elaborate further on my paper. It is not only the parties that should be wary here. The governments and the legislators, they need to rethink the majoritarian rules. They need to rethink force majeure and hardship clauses so that they're still majoritarian rules applying to the majority of the cases and requiring deviating agreements between the parties only exceptionally. Perhaps renegotiation, adaptation, termination should be on the agenda when revising these particular national and international uniform law instruments. Thank you very much for listening to me. I'm all ears for questions if we have time. And again, sincere apologies for running late.
That's all right. We have one question from the floor, and depending on how long it takes you to answer that, I'm very tempted to abuse my position as the moderator to pose another question / observation. But the only one I have, let me make sure that I'm right when I say this. So far, I only have one question from the electronic floor. It's from Shmuel Yerushalmi. I hope I pronounced that right. Forgive me if I haven't. Let me quote it to you. The question is this. Say, please, what are the opportunities creating COVID-19 pandemic for private law? What are the opportunities for private law? I think it means what are the opportunities created for private law by the COVID-19 pandemic? That's Mr. Yerushalmi's question.
Excellent, excellent. Thanks a lot for this question. And I think that ties very well with the future perspectives. Well, the opportunity is to have a close look at national legislation and international uniform law instruments and see what are the shortcomings, not only of the particular national rules, not only of the particular hard law instruments that have taken the form of an international convention, but also see what are the shortcomings of law generally speaking. Perhaps referring the parties to an adjudicatory authority, say a court, and having thousands of cases because we have thousands of contracts that need to be adopted might not be feasible. Perhaps we might need to introduce special clauses with regard to cross-border situations pertaining to force majeure and hardship situations. Besides, we live in a globalized world. And the last aspect that I would like to emphasize, and I did not have the time, and again, apologies for that, I did not have the time to elaborate on that, is to think about overriding mandatory rules and how overriding mandatory rules were used. Overriding mandatory rules is a tool that we have in private international law and conflict of laws, which illustrates the public considerations of a particular state. And essentially, an overriding mandatory rule says, I do not care what the applicable law is. I will apply here, I will regulate the situation at hand. And we have seen during the past 2 years, states using this particular tool of unilateralism to escape this multilateralism of private international law, to escape the Committee of Nations, which has led to the application of foreign law as well in a protectionism manner. But to conclude in a positive tone, we have seen the shortcomings of national law, the shortcomings of international law. And that is a great opportunity to rethink and to go back to our sketchbook, to redraft our national laws and our national rules on these particular points, because they are not only linked to merchants and businesses and the evil money and capitalism, but they're also linked to the affluence of their societies. If we can get the products in a timely manner, if we can adapt the contract and keep companies alive, we keep employees alive, we keep hospitals open, we keep goods traveling the world. And I think that is the positive way of answering this particular question. Thank you.
Yes. Thank you so much. That's most interesting. I've sometimes when I attend academic sessions, I come away thinking privately and quietly to myself, that's an hour or 2 hours out of my life I'm never getting back. It's always a pleasure not to have that thought when one leaves an academic seminar. This is one of those occasions when I think the irreplaceable hour and a bit has been very well spent. Just in relation to like one of the mega questions that you posed at the outset, which is namely, does private law have the tools to cope with the sorts of problems thrown up by pandemics such as COVID-19? It seems pretty obvious based on your presentation this evening that the answer is yes, far too many. It's got far too many tools and they're all incompatible with each other. That appears to be the problem. It's like the tourist who goes to a hotel with many different adapter plugs, but none of them slot into the wall. So that appears to be the real problem. If I can put it in a perhaps oversimplified nutshell, that appears to be the problem that you've outlined here tonight so very ably and with such obviously skillfully engaged in research. So on behalf of the Chinese University of Hong Kong Faculty of Law and the Center for Comparative Transnational Law, and on behalf of all of the attendees here this evening and myself, I'd like to thank you so very much for giving us the benefit of your research. And I have no doubt that King's College London is very well served by your presence on its faculty. So thank you so very much. And to all of our attendees here this evening, thank you for your attendance and your attention. And we hope to see you at least some of our future events.